Okay. Okay, so good evening, everybody. To our guests, welcome to the British Law Centre at the Faculty of Law and Administration of the University of Warsaw. I am very happy to be able to introduce our special guest this evening. Alastair Hodge is a barrister practicing in England and Wales. He is a bencher of the Honourable Society of the Inner Temple and Master of the Revels. He is a professor of advocacy, and to me, he is an absolute inspiration. To me and to the hundreds of advocacy pupils that he teaches in jurisdictions all over the world every year. He's also a really good friend of the British Law Centre, and he's taught advocacy for us here at the University of Warsaw on many occasions and at other BLC centres as well. What I wanted to say was to Alastair himself, one of the many casualties of the COVID pandemic is that we just haven't been able to see as much of him as we would like, and I hope I see that is now going to be remedied a little bit by him visiting us in Warsaw today. So before I hand the floor over to Alastair, I just want to say thank you to the Warsaw Bar Association for helping to organize the event, and specifically to Anna Atanasov and Wojciech Baginski. And without further ado, I would like to welcome our guest this evening, Master Alastair Hodge.
Thank you very much indeed. No, shush. There'll be time for applause later, I assure you. I never know how to start lectures. I always sort of pace up and down and sort of gauge my audience and look into their eyes and try and work out, what they're thinking. Are they thinking this man is mad? What are we doing here? But you're very welcome, and it's a great pleasure to see you all here this evening. The subject of this evening's right is the art of cross-examination, and an apt subject it is. There is nothing more challenging, more difficult, and more amazing than the art of cross-examination, where you as the advocate in a courtroom attack the credibility or the evidence of a witness on the other side. And I'm going to teach you how to do it in about an hour and 10 minutes. But before I do, some foundations, if I may first please. It's been thought for many years, or it was thought for many years, that advocacy is a skill, whether it be examining your own witnesses, whether it be doing speeches, whether it be making submissions, whatever it is, it was thought that advocacy as a skill could not be taught. Come back to the 1940s, the 1950s, principally in the United Kingdom. How did barristers back in those days learn the skills of their trade? Well, it was quite simple. You appeared in front of such brutes as Mr. Justice Karminski, and Mr. Justice Karminski would systematically sever the advocate limb from limb, and blood would be splattered all over the walls, and the advocate would hobble out at the end of the performance, battered and bruised, but would have learnt from the experience of being savaged by Mr. Justice Karminski. But in the 1960s, there was a seed change. Not here in Europe, far from it, but in two foreign jurisdictions in particular. Firstly, in America. In America, there was a judge called Irving Younger who sat in New York City, and he sat as a judge for many years, and he was sick and tired of seeing on a daily basis bad advocacy displayed in his courtroom by the American lawyers. So what did he do? Well, he gave up being a judge, and he set up an institution in America called NITA, N-I-T-A, the National Institute for Trial Advocacy, which still exists today. In fact, I've had the pleasure of teaching at NITA. It's a wonderful institution where the young American lawyers can go and learn the skills of examination in chief, cross-examination, etc. Around the same time, in the late 1960s, in Australia, you had George Hampel. Now, George Hampel is very much a friend of ours here in Warsaw, because I think he was born here, wasn't he? We last talked with George here in 2019. And if you ever meet him, he's 89 years old now. And he is, if you like, the founding father of European advocacy training. And if you ever meet him, he's amazing. He is the human embodiment of a fusion between Dobby the house elf from Harry Potter and Yoda from Star Wars. He's about sort of 4 feet 11 high, and of course he's Australian, so he's got an Australian accent, and he stands there with his little iPad mini and throws a couple of steaks on the barbie and has a schooner of beer while teaching advocacy. That's George. And George is largely responsible for bringing the idea that advocacy could be taught to our jurisdiction here in the European Union. Irving Younger, who I referred to a moment ago, sadly he's no longer with us. He died on the 17th of March of 1986. But his legacy as one of the founding fathers of advocacy training lives on to this day. Anthony Leonard, a man of whom you should be afeared. But back in the early 1990s, when George Hampel visited the UK, he sold the idea that advocacy, that cross-examination as a skill could be taught. And he met with some of the members of the Inns of Court, some senior people from the Inns of Court, and said to them, this can be taught. You can teach lawyers, advocates, the art of cross-examination. And Anthony Leonard now sits at the Old Bailey as a judge, as a criminal judge. And it led Anthony in 1997 to deliver a lecture on advocacy, in which Anthony said there were 3 rules of advocacy. The first was preparation. The second was preparation, and the third was preparation. And as Anthony said back in 1997, if there were to be a 4th rule of advocacy, it would be preparation. And back in 1997, I guess Anthony was right. I've taught advocacy all over the world, and I'm totally persuaded that I could take a group of aliens from the planet of Saturn with no knowledge of how to be an advocate, and by equipping those aliens with a system of preparation, I could turn them into good advocates. I could turn them into effective advocates. I could make them the Vladimir Horowitz of the Warsaw Bar, to be able to stand in court and look at a witness and cross-examine and be effective. So what of cross-examination? What are the purposes of cross-examination? Let's start with that. Well, let's introduce it at a very basic level. It is where you, as the lawyer, are going to ask questions of a witness on the other side. For want of a better phrase, the enemy. It's a witness you don't like. It's a witness that you don't want the court to believe. But how are we going to get across to the court? Through asking that individual questions, that they are an individual that is not to be believed. And I'm going to teach you how to do it tonight. Well, in the space of about an hour. Whether I can achieve my objective or not, I have no idea. But let's lay some ground rules first. What are the fundamental principles? What are the reasons why we cross-examine? Well, number one, to put your case. Let's assume, gentleman here, what's your name? What? Grzegorz. Pronunciation is going to fail me, I'm sure. I speak very little Polish, as you will find out. But Grzegorz, let's say that Grzegorz is a witness in a case, and it's his evidence to the court in a case that on a particular day, he arrived at work at 9 a.m. in the morning. I'm the advocate on the other side. I don't think he did arrive at 9 a.m. I don't think he arrived until 11 a.m. because the previous night he was out drinking Mad Dog shots, which I believe is a very popular drink here in Warsaw. Tabasco sauce, raspberry cordial, and vodka. So what I have to do in cross-examination is I have to challenge him. I have to put my case to him. I say, Grzegorz, it's right, is it not, that on the 3rd of March you didn't arrive at work until 11 a.m.? And he will stick to his guns, because witnesses do. He will say, no, I got there at 9 o'clock. It's then up to the judge to decide whether I'm right or whether Grzegorz is right. So that's what I mean about challenging the evidence of a witness, putting your case to that witness. What's the second purpose? Well, the second purpose is really the next 2 bullet points. To test the credibility of a witness. Is Grzegorz a slippery individual? Is he a man who is to be believed? Do we like him? Is he a man that we want to, at the end of the case, say, yeah, he's an okay guy? Or do we want to say he's a liar? Or do we want to say he's misconceived, that he's got things wrong? That's what we mean by testing the credibility of a witness. And going hand in hand with that, we're going to test his consistency. I'm sorry I'm picking on you all the time. I will pick on somebody else in a moment. But I'm going to test the consistency of his evidence. Has he stuck to his guns all the way through a particular piece of litigation and said the same thing all the way through? And the last purpose of cross-examination, probably the most trivial, but without doubt, in my view, the most important. It's to have fun. Because there is nothing better, ladies and gentlemen, that when you cross-examine a witness and everything clicks, that you get that witness into a corner, not necessarily Gregorz, but you get that witness into a corner and there's nowhere for them to run. And because there's nowhere for them to run, the feeling that goes through your body is amazing. You will feel as though you are on cloud nine, as though you had already ascended into heaven. It feels that good when a cross-examination works. They don't all work. I make that concession. You will not carry out a successful cross-examination every time you do it. But how do you do it? Where's my clicker? There it is. How do you do it? Most lawyers, in my experience, all over the world, do cross-examination badly all the time. No lawyer, myself included, does it brilliantly all the time. And no lawyer in the early stages of his or her legal career does it well at all. I am totally persuaded of this, and I'll tell you why. Because in order to be an effective cross-examiner, in order to be a good cross-examiner, I think you need three things. And when I tell you what these three things are, I'm sure you will agree with me that in the early stages of one's career, you will cross-examine very poorly. What's the first thing the effective cross-examiner needs? The effective cross-examiner needs what I call a total mastery of the rule of trial advocacy. That is to say, a sound knowledge of the law of procedure and the law of evidence as it applies to the jurisdiction in which you practice. You must be a master of those fundamentals, folks. But I'm not going to turn this evening's sessions into a lecture on procedure or a lecture on evidence. Why? Because it would be dull, because it would be boring, it would lack engagement. And in any event, I take it for granted that each one of you in this room, if you want to cross-examine, can acquire this fundamental for yourselves by going online, as some people are, a sort of Windows tablet thing, a MacBook thing at the back there, by going online and reading what there is to be read on the law of evidence or the law of procedure as it relates to the jurisdiction in which you practice. So I take it for granted that each and every one of you can acquire that fundamental for yourselves. What's the second thing the effective cross-examiner needs? The effective cross-examiner needs experience. What do I mean by experience? I mean 50 cross-examinations under your belt. How many people in this room have cross-examined a witness more than 50 times? I appear to be in a minority of one. Why do I say 50 cross-examinations? Because that gives you your sea legs. You see how different witnesses respond to different types of question, to different styles of question. If we had more time together, one of the things that I'm totally persuaded of that I would never do is that in advocacy training, I would never teach you a style. You've all got your own backgrounds. You've all got your own life histories. You've all got your own personalities, your own accents, your own voices. I would never teach you to speak in a particular way. That's wrong. When you're an advocate, you bring yourselves to the party. And when I cross-examine, invariably, I am me. I sit there or I stand there in court and I am me and I put questions to a witness. But sometimes I'll deploy a different style. Part of my work is employment law. And if, for example, I've got a managing director, hello, good evening, lovely to see you. The managing director is sitting there in court, and I'm the cross-examining advocate, and I could cross-examine as me. That could be effective. But sometimes I deploy a different style. For example, the Hannibal Lecter style. Now, Mads Mikkelsen in the TV series was good, but Tony Hopkins was better. And there is nothing like looking at a witness and getting up close to them and putting on the Anthony Hopkins voice and saying, good evening. That's a very attractive nose that you have under that mask. I'm going to bite it off and eat it. You know, and the managing director is like, whoa, this guy's crazy. And indeed, I am crazy. But of course, it puts them on the back foot and it puts them off guard. I don't know whether you have it here in Poland. But in America, there used to be in the 60s, 70s, and 80s a very good television program about a detective in Los Angeles called Columbo. You go, oh, lots of nodding of heads. Yeah, Columbo. You remember Columbo with the raincoat and the cigar? And Columbo, if you remember, always gave off the impression that he was an idiot, that he had no idea what was going on. And sometimes I deploy that style in cross-examination. I say, Miss Witness, I'm terribly sorry. I wonder if you could help me. I'm having difficulty following this. And it lures the witness into that false sense of security. And 10 questions later, the witness is in the palm of my hand because you've sent them down the garden path on that little tangent. But stylistically, you find your own style. But experience, there is no substitute for 50 cross-examinations. And there's a third thing you need. The last time I was in Warsaw, Dr. O'Neill and Dr. Terrett said I shouldn't say this. They said it was considered elitist, non-politically correct. But I don't care, because it's true. You need talent. And you've either got the talent to be a cross-examiner, or you haven't got the talent. You know, think back to when you were born, when you all came out of your mother's wombs as babies, still connected to the cord. Either God was there in the delivery room to go, cross-examination talent, or God was elsewhere in the world saving a rainforest, or whatever it is that gods do when they are not bestowing cross-examination talent on babies in a delivery room. And if you find you don't have the talent, don't be sad. Why be sad? There's nothing you can do about it. Huh? Maybe your talents lie elsewhere. Maybe sitting in a dark room of Clifford Chance, drafting corporate debenture clauses or something like that. Maybe your talents lie there. Or maybe you will find, folks, as you go through life, that your talents lie beyond the law, and it sends you to dental school or become a dentist or whatever it may be. I can see the gentleman here. He's thinking I'm quite telepathic when it comes to lecturing. I can see what this gentleman is thinking. He's pieced it together in his mind. He's thinking, well, hang on a minute. If you're not going to tell us about the law of evidence or the law of procedure, because that would be boring, and we've got 55 minutes, I can't, for each one of you, in the space of 55 minutes, recreate 50 cross-examinations for each of you, so as to give you the experience. And contrary to what you might be thinking, I am not God, and therefore I cannot bestow upon you the talent necessary to be a cross-examiner. The question you want to ask me is well-founded. Why do I dare stand here and pace up and down and seek to tell you about cross-examination? Well, it's simple. I don't think that anybody in the space of 55 minutes can make you a good cross-examiner. I can't do that. That's beyond my power. But I will bet my reputation and my career that in 55 minutes I can stop you all from being bad cross-examiners. And that is my limited objective for the next 55 minutes. How do I do it? Well, I do it by giving you a series of rules. And there are 10 of them. And we call the rules commandments. They're therefore called the 10 commandments of cross-examination. And the 10 Commandments of cross-examination was the original brainchild of Irving Younger, the American judge that I referred to a little while ago. And he came up with his original commandments in 1969. But of course, 50 years have passed, different areas of thinking, different types of thinking, different approaches to cross-examination. And of course, Irving Younger's commandments were all geared towards the American audience. And as you'll know, I hope it doesn't happen here in Warsaw. If it does, it must be stamped out. For those of you who know, all American lawyers, when they cross-examine, adopt that pose. You know, this is just something that all Americans do. I have no idea why. I don't think the ladies do it, because it might get quite painful there. But all American male lawyers cross-examine like that. So what I've done is I've taken his original 10 commandments, stripped out the ones that are now archaic, and added in some of my own that are all relevant to modern advocacy practice, whether here in Poland, in the EU, or anyway in a Western jurisdiction. And my advice to you is simple. If you go into court, or if you're learning advocacy, or you're prepping, if you're here at the university and exercise for Dr. O'Neill, you know, it's very simple. Never, ever, 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 ever violate any of these commandments that I give you. Because when you do, two things will happen. Number one, you remember me, the madman, looking at you saying, thou shalt not violate these commandments. And number two, if you do it when you're in court, if there are any advocates here from the Warsaw Bar, good evening to you. When you do it in court, you'll stand there, you will put a question to a witness, you will break one of my rules, and two things will happen. You will let off a high, shrill, pitched laugh. And you will want the ground to open up beneath you, that you will sink into the ground slowly, it will cover you over, and you will never be heard from again. That is how you will feel when you screw up in cross-examination. Of course, there are exceptions for the virtuosi. For the experienced cross-examiner, for the talented cross-examiner, we will be at liberty to depart from any of these rules with a click of a finger. Why? Because we can. Because we have the experience, we have the talent, we know what we are doing. But until you acquire the experience, or indeed find you have the talent, never, ever, ever break any. Good evening, dobry wieczór. That's about the limit of my Polish, for those of you who are following so far. Vodka. Sklanka whiskey, also important. Of course, there are exceptions for those with the experience and the talent. We will be at liberty to depart from these rules with the click of a finger. Why? Because we can. And I'll be telling you a story a little bit later on of a classic occasion when I deliberately broke one of the rules, but for effect, because I knew what I was doing and I got the reaction from the witness that I wanted. But until you get to that stage, never, ever, ever break any of these rules. Each commandment, for those of you who've got copies of the slides, if not, they're going to be shown up here. Each commandment, each rule can be shortly stated. It's very, very short. And what I will do is I will state the commandment. I will then sketch in a bit of background as to what I mean by the commandment. And of course, each commandment is accompanied by a story, a demonstration, an anecdote, etc., to illustrate the rule in practice. So, rule number one, be brief, short, succinct. I see it day in and day out in court, ladies and gentlemen, the cross-examination that goes on and on and on and on. And you see the judge develop, if they're right-handed, what I call the left elbow routine. The left elbow goes on the chair and the head goes in the hand. Why is Mr. Hodge asking all these irrelevant questions? But in theory, if you are properly prepared and you know the areas, going back to our example, you know the areas where you want to challenge the evidence on the other side, you will be brief. You will have identified as part of your preparation of the case what you need to challenge, as I did with you. You stand up, you put those challenges, and you sit down. Cross-examination, folks, is not the invasion of Europe. It's not a bunch of generals sitting behind a table moving a tank division an inch closer to Berlin. That takes hours, that takes days. Cross-examination is a commando raid. Think back, for those of you who are old enough, probably none of you are looking around the room, but I think back to 1980. And in 1980, I was at primary school. I was only, 7 years old. And we were sitting in the primary school room and there was a television. And on the only 3 channels on the television back in 1980. How wonderful would that be now, rather than all the crap that they show on Sky. And we're all looking at this television and it's a picture of a white building. And all is quiet. Nothing happens. And then all of a sudden, ropes come off the roof of the white building, and men dressed all in black with gas masks come down the ropes and kick in the windows, and grenades go off. Boom! And 40 seconds later, the hostages run out of the front door. Well, ladies and gentlemen, that was the Iranian embassy siege in London back in 1980. And that's cross-examination. It's fast, it's furious. Stand up, put your points, and sit down. I should say, there's another reason for being brief. I hope I don't cause offense by what I'm about to say, because it's true. So we might as well just dispense with any complaints about me. Sorry. If there are any complaints, just direct them to Dr. O'Neill. When you cross-examine for the first, second, third, fourth, fifth, up to 50 times, you can take it from me, you are doing a terrible job. You might as well just accept it. Let's just get that out in the open. You're doing a terrible job. Therefore, by parity of reasoning, the less time that you are actually on your feet asking questions, the less damage you will be doing to your own client's case. Because you will damage it by asking too many questions or asking the wrong type of questions. So be brief, work out what you need to challenge, stand up, put it, sit down. Commandment number 2. Commandment number 2 goes hand in hand with this first commandment of being brief overall, and is in relation to the actual length of question that you ask. And as you'll see there, it says 1 point per question. What do I mean by that? I mean quite simply, every question you put to a witness in cross-examination should contain only one piece of information. Let me try and illustrate this by way of a demonstration. The cross-examiner who contravenes this second commandment might ask something like this. A lady here who's taking notes. I've got highlighter pens. How exciting. Look at these. Oh, very lovely. Excuse me. Oh, very nice. What's your name? Anne. Anne, right. And you're the witness in this. And the cross-examiner that breaks this second commandment might ask Anne something like this. Anne, on the 3rd of March of 2021, you arrived at work at 9:30 a.m., and the first thing you did was park your car in the office car park, which is located immediately opposite the office building on the other side of the road. And having parked your car, you got out of your car, locked your car, and then walked the 25 meters or so to the office building, which has a glass door, which you went through, and on your left-hand side was a security desk. John was on duty that morning. You said good morning to John. He said good morning to you, after which you went to your office, which is on the ground floor, and on your desk in your office was an envelope, which you picked up, opened, and read the contents inside, and it was a letter from your managing director inviting you to a meeting at 10 a.m. That's right, isn't it? And of course, the silence falls because Anne has no idea how to answer that question. If indeed, folks, it was a question. Hence the second commandment. Any question you ask of a witness should only contain one piece of information. Let us now, Anne, if you would, please, let us redo that cross-examination. Just for the purposes of the demonstration, answer yes to every question that I ask you. But here it is, complying with the second commandment. Big booming voice, Anne, because I don't know whether it'll pick it up on the mic, but who knows. But for everybody else, big booming voice. Anne, on the 3rd of March of 2021, you arrived at work at 9 a.m., did you not? The first thing you did was park your car. That's right, isn't it? You parked your car in the office car park, didn't you? The office car park is on the other side of the road, the office building, isn't it? And having parked your car, you got out of your car, didn't you? You locked your car. And then you walked the 25 yards or so, 25 meters or so, to the office building, didn't you? The office building has a glass door, doesn't it? You went through that glass door, didn't you? On your left-hand side was a security desk. Do you remember that? John was on duty that morning, wasn't he? You said good morning to John, didn't you? He said good morning to you, didn't he? You're in love with John, aren't you? You then went to your office, didn't you? Your office is on the ground floor, is it not? Your office has a desk, doesn't it? And on your desk there was an envelope, wasn't there? You picked up that envelope, didn't you? You opened that envelope. Yeah? And you read the contents inside, didn't you? And it was a letter, wasn't it? It was a letter written by your managing director. And that invited you to a meeting at 10 a.m., did it not? You see, one piece of information per every question I asked. Not two, not three, but one. Why is one piece of information important? Two reasons. Number one, if you're only asking a witness about one particular thing, you will find in practice that because your question is so short, that their answer will be short. And secondly, by only dealing with one piece of information in each question, you will find that you retain total control over your witness. So how do you do it? For those of you either in practice at the bar or for those of you about to do an exercise for Dr. O'Neill, how are you going to do it? Well, I'll tell you what I do. When I prepare my notes for questions in cross-examination, I write my questions on a Word document, 12 CPI, type them, and then I save it, I go and have a glass of whiskey, and I come back to it. And it's a visual check that if I see that I've written a question that runs to a second line of text, in other words, it goes to a second line, then arguably it is too long. And what I will do is I will look at it, I will chop it, I will change it to make sure that every question I am going to ask is on one line and one line only. And if you really want to take it, and this involves in my case, another glass of whiskey. Yes, I am usually drunk by the time I've prepared a cross-examination, this is true. But if you want to really go to the nth degree, imagine the screen here being a Word document. I know it isn't, but it isn't a Word document. Not just have your points on one line and one line alone, but make them only go halfway across the page. And that will really give you short questions in cross-examination to retain that ultimate control. Commandment number 3, simple language, plain words. You must acquire the knack, folks, as an advocate of using simple language and plain words. There are, of course, exceptions. If you ever get to the point in your career as an advocate where you have to cross-examine, for example, an expert witness, you're going to be using technical terminology with which the expert will be familiar. But if you're cross-examining a lay witness, whether it be a managing director or an employee or whoever it is, you must acquire the knack of simplicity. Let me give you an example of this. When I started at the bar in 1997, I must have done, I don't know, maybe 800, maybe 1,000, what I would call road traffic cases, where you would go to court acting for a driver and they'd had a crash, the two cars had come together, and you were arguing over who was at fault. And in only a handful of those cases did I ever hear an opponent of mine use the word bus or bike or car. They thought, I'm an advocate. I need to use flowery, exotic language and sound like an advocate. So they would always say, vehicle. You know, never would I hear an opponent of mine in a case say to a witness, how were you driving? Now, how simple a question is that? How were you driving? The witness will understand the question. They'll say, I was in third gear or whatever gear I was in, driving along Turner Avenue, and I turned left into Matthews Road. But did they ever ask a witness, how were you driving? No. They thought, I'm an advocate. I'm exotic. I need to use flowery language and sound exotic. So they would never say, how were you driving? They would say something like, and tell me, please, what did you then do with regards to the operation and control of your motor vehicle? Now, it might sound exotic, it might sound flowery, but it's actually bad advocacy. Simplicity. Give you a further example of this. A few years ago, I went to Carlisle, which for those of you who know the geography of the United Kingdom, it's a town up towards the Scottish border in Cumbria. And Carlisle is a lovely city. And I was there to do a case where I had to cross-examine a scaffolder, one of these men who puts up scaffolding and takes down scaffolding. And no disrespect to him, he had no measurable IQ whatsoever. He left school with no qualifications or anything, but he was an absolute expert on putting up scaffolding and taking down scaffolding. A man of limited intelligence. And therefore I knew when I cross-examined him that I needed to use simple language, that I needed to use plain words, that he would understand every question that I asked him. And here's your yardstick, and it didn't happen to me in Carlisle, and here's the yardstick. If you carry out a cross-examination, and in respect of one of your questions, your witness replies, aye, what do you mean? Don't understand, what are you on? Or words to that effect, that they don't understand the question. The fault, ladies and gentlemen, is not the witness's. The fault is yours, because you have not asked that question in a simpler way so as to permit the witness to understand it. And that's your target. When you go out into the big wide world and cross-examine, never, and it's death to the cross-examiner, if you get a witness who says, I don't understand your question, what are you, I don't, what, the fault is not the witness's, the fault's yours. And that's your yardstick. So, How are you going to do it? How are you going to make sure that all of your questions in cross-examination are simple? Well, it goes hand in hand with the second commandment. Because when you're checking that your questions only go halfway across the page, also look at the language that you've used. And just say to yourself, can I use a simpler word here? Is there a simpler way of asking this than the one I've written down? And if there is a simpler way of doing it, change it. It's back to preparation, preparation, and preparation. Fourth commandment. I'm going to have a little bit of a pause here to carry out a little exercise. I love this bit. This is always good fun. And she doesn't know it yet, but Anna is going to be my stooge for this. Because I always like to have a stooge. I always like to have someone that I sort of make fun of and embarrass during a lecture. And Anna's just decided to volunteer. The fourth commandment, as you'll see from the screen, leave that there, only leading questions. Now you might think, oh, well, that's easy. That's nice and straightforward. I only ask leading questions. But of course, it would be wrong for me to leave it just at that, because many of you may be thinking, well, Alastair, what's a leading question? So therefore, we shall take a moment to illustrate to you what I call the three categories of question. Okay? Category 1, Category 2, Category 3. And the way we do this is I'm going to ask Anna 5 questions. I want you to answer. They are personal questions. There's nothing intrusive. I'm not going to ask for your life history or anything like that, but you should know the answers to them. And if complex Polish words are involved, say something else, because I'll just struggle for the purposes of the demonstration. So I'm going to ask Anna 5 questions. I want everybody to listen to the questions that I ask, listen to the answers that Anna gives. I'm then going to ask her the same 5 questions, but in a different way, and we'll have a little bit of a discussion. And I'm then going to ask her the same 5 questions in a third way, and we'll have a little bit of a discussion. So you're going to get 3 different categories of question. So here we go. What is your name? How old are you, Anna? How old? 50. Where do you live? How long have you lived in Warsaw? And how did you get to the lecture this evening? By what mode of transport? Thank you. 5 questions asked, 5 questions answered. I now, folks, ask the same 5 questions, but in a slightly different way. Listen carefully. Your name is Anna, is it not? You're 50 years old, aren't you? You live in Warsaw, don't you? You lived there all your life, haven't you? And to get here this evening, you came on foot. Thank you. Come back to you in a moment. In the first set of questions, from whom did the evidence come? Where was the evidence? Who was the source of the evidence? She was, Anna. In the second set of questions, from whom did the evidence come? Me. And that, ladies and gentlemen, is the easiest way to determine whether a question is a non-leading question or a leading question. It is to look for the source of the evidence. The first set of questions, non-leading questions. Why? Because the source of the evidence was Anna. Anna, 50, Warsaw, all my life, foot. She said that, not me. The second set of questions are leading questions, because the source of the evidence is the advocate. Your name is Anna. You're 50 years old. You live in Warsaw. Lived there all your life. You came here today on foot. Yeah? But there's a third category of question about which you need to know. So what we'll do is we'll replay category 1 and 2, and then we'll launch into category 3. And all I want you to do, once we've done it, is I'm going to do a survey. I'm going to ask you for a show of hands. Who thinks that category 3 are leading questions, and who thinks category 3 are non-leading questions? Okay? So, to refresh your memories, category 1, what is your name? How old are you, Anna? Where do you live? How long have you lived in Warsaw? And how did you get here to the lecture hall this evening? There you are, category 1. Category 2, your name is Anna, is it not? Your name is Anna, is it not? You're 50 years old, aren't you? You live in Warsaw, don't you? Lived there all your life. And to get here tonight, you came by foot. Listen carefully. Is your name Anna? Are you 50 years old? Do you live in Warsaw? Have you lived there all your life? And to get here this evening, did you come on foot? Hands up all those who think that category 3 were leading questions.
Oh, I'm not going to put my hand up until somebody else does.
Yeah, fair few. How many think that category 3 were non-leading questions? Ah, yes, a few, yeah. Somebody tell me, somebody who said leading, why do you say they were leading? Don't be shy, I don't bite. Yes, gentlemen there, yeah. Thank you very much. Absolutely spot on. Is your name Anna? Are you 50 years old? Do you live in Warsaw? Have you lived there all your life? Did you come here tonight by foot? The source of the evidence, you quite rightly say, is me. And if the source of the evidence is me, it's a leading question. But it's no bad thing, folks, that some of you said non-leading. I think the gentleman here with the very attractive beard that I can't see, why did you say they were non-leading? Exactly. So therefore, assuming that we're right, or assuming I'm right, that the source of the evidence being with me is that category 3 are leading, what then, folks, is the difference between, let's build on your answer, what's the difference between category 2 and category 3? Let's give them to you again. Your name is Anna, is it not? You're 50 years old, aren't you? You live in Warsaw, don't you? Lived there all your life. And to get here tonight, you came on foot, didn't you? Is your name Anna? Are you 50 years old? Do you live in Warsaw? Have you lived there all your life? And did you come here tonight by foot? What's the difference between 2 and 3? Do you want to develop your answer a little bit more? Yeah. Yeah. Superb. Absolutely superb. In essence, to take your answer and put it into the way I would describe it, in category 2, I am suggesting the answer. In category 3, I am suggesting an answer. Not necessarily the answer, but an answer, because as you say, it gives her more of an opportunity, to develop. But we're talking about cross-examination. What's the 4th commandment? Only leading questions. In other words, when you are asking questions of a witness on the other side and you're cross-examining, never, ever, ever ask a category 1 question. Because the consequences for you as the advocate can be unreal. Your name is Anna, is it not? You're 50 years old, aren't you? You live in Warsaw, don't you? Lived there all your life, haven't you? And to get here tonight, you came on foot, didn't you? Why didn't you take the bus? Have I got the slightest control over the answer she gives? No, because I've asked a why question. A why is a category 1 question where the source of the evidence is not in the question. And that allows Anna to say whatever she wants to say. And ladies and gentlemen, in cross-examination, it's not your job to let Anna say what she wants to say. You make her say what you want her to say. And that illustrates the danger of asking a category 1 question. Stick to category 2 questions with the odd category 3 question thrown in if you want. But category 2 all the time. Short category 2 questions is what you want. With one exception. Where you can ask a category 1 question, but for effect, in order to achieve a particular purpose. But you can only do so where it's a win-win situation for you. Let me give you an example of this. I did a case some years ago where I was cross-examining a witness. In fact, in this case, I cross-examined them for 6.5 days. Now, you guys are lucky. You've only got me for 1 hour and 15 minutes. But can you imagine for 6.5 days of your life to have me asking you questions? Trust me, it would be far more pleasurable for me than it would for you. Huh? But we got to a particular allegation in this case. And the allegation was that a manager had failed to interview 3 individuals. It was in an employment context. It involved a grievance. And the employee that I was cross-examining had had a meeting with the investigating officer. And in order for the investigating officer to actually interview these people, she had to know to interview them. And essentially, we had a transcript of the meeting. And at no stage during the meeting did the employee say, oh, you've got to interview Peter, you've got to interview Jane, you've got to interview James. And so when I cross-examined her on that, we went to the transcript of the meeting, and I used a Category 1 question. I said, where in that transcript do you ask her to interview Peter? And that passes the reins over to her. That means that I don't have control anymore. But I got the reaction that I wanted because she was glancing through all the pages. And eventually she flipped and screamed at the top of her voice, it's in here somewhere! I know it! I know it! I know it! And I just sat there and went. And sometimes that can be a very powerful tool when it's a win-win situation, when you're asking a witness to actually go and look for something that doesn't exist. But you need to, of course, be prepared. You don't want to then ask the question, well, show me where in there you say, contact Jane. And the witness goes, 3rd page, 2nd paragraph. Problem. You've got to do your homework. You've got to do your preparation again. But that's the only exception, leading questions. Commandment number 5, listen to the answer. This is a new one that I've only begun to develop recently. And it's an absolute beaut. Because from time to time, folks, witnesses will say the most extraordinary things in cross-examination. And you're too busy looking at your notes or working out where you're going next that you don't actually listen to what the witness says. God gave you 1 of these and 2 of these for a reason. And I think that's all to do with cross-examination. Because from time to time, a witness will give you an absolute nugget of beauty. In this same cross-examination that I'm talking about, I developed it that there was no mention of being suggested to interview these people. And so I actually asked the witness, I said, are you telling the employment tribunal that you expect this witness, this lady to be psychic? Which, of course, is a ridiculous question. And 99.9% of the population would answer no. But the employee in this case was mad enough and answered yes, saying that she thought her manager should be psychic and be able to read her mind. How ludicrous is that? Make a note of it, take a note of the ridiculous answer, and then use it later on if you want to make arguments on credibility. But don't ever wade in. If you get a ridiculous answer, don't try and explore it, because again, you're into uncharted territory. You're sort of going into avenues that you haven't fully prepared. Although having said that, in this same case, I did break my own rule, but that was talent and experience, because I did wade in, and I got the reaction, no, 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 of course I meant no, of course I meant no. You're getting inside my head again, Mr. Hodge, and I hate it when you're inside my head. And I was like, yeah, best compliment I've ever had from a witness in any trial. But listen to the answer. From time to time, you will get the odd nugget. Number 6, don't quarrel with the witness. Now, aside from this being unprofessional, it just doesn't look good. It doesn't do your credibility as the advocate any good. Of course, from time to time, folks, you will need to be firm with a witness. You've asked a very simple leading question to which the answer will be yes or no, and the witness is wriggling. Just be firm with them. Say, sorry. Maybe you misunderstood me. Let me put the question again, and put the question a second time, and you will find that the witness will usually then answer the question properly second time round. Quarreling with a witness, in my experience, usually arises in 2 different scenarios. Firstly, what I call the tennis match cross-examination. Lady here. The answer to every question I ask you is no, I didn't. Okay? Yeah? On the 3rd of March at 9:30 a.m., you arrived at work, did you not? Yes, you did. Yes, you did. Yes, you did. You did! And so on and so forth. It gets you nowhere. It's like a tennis match. It's batting the ball either side of the net. I have challenged the point. I have put it to the witness that they arrived at a particular time. They've said no. Unless I've got other evidence, nothing on God's earth will persuade the witness that it was anything other than 9:30. But the second arena, and I think back to previous advocacy courses that we've done here in Warsaw and also in Gdansk. Gdansk was a particularly good one, where we really had a wonderful example of an advocate who forgot that this is an exercise in cross-examination, and he turned it into an exercise in examining crossly. And yeah, you've probably seen it. Yeah, and guys, never go into a cross-examination with the desire to be nasty to a witness, to deliberately harass a witness, to be angry with a witness. It's bad advocacy. As I said to you earlier, there are times when you might want to be firm with a witness. That's fine. But no to actually going in to be deliberately nasty to them. It won't do your credibility any good whatsoever. For those of you, I haven't really got a great example from my own practice to illustrate this, but for those of you who know your 20th century European history, you may probably know as much about this as I do. At the end of the Second World War, when the Nazi regime had been defeated and Hitler was dead, many of the senior Nazi leaders were still alive, and they were arrested by the Allied forces, the French, the Americans, the British, and the Russians. And they were put on trial in a war crimes court in a town in Germany called Nuremberg. Nuremberg is obviously famous for the Nuremberg trials, which is what I'm talking about, but also a particularly brutal opera by Richard Wagner called Die Meistersinger von Nuremberg, an opera that lasts over 6 hours and is particularly brutal and, if I may say, tuneless. But anyway, at Nuremberg, all the trials took place, and the Allied forces decided that they would send along to Nuremberg a historian, and it was an English historian called John Wheeler Bennett. And John Wheeler Bennett wasn't a lawyer. His role at Nuremberg was to make a record of all the trials that took place, and then after all the trials had happened, he would produce his magnus opus. It's text about that thick, where he would set out a historical record of all the trials at Nuremberg. Most of that book, ladies and gentlemen, is contemptible as literature. It's the most boring thing you would ever wish to read, save for one section, where John Wheeler Bennett describes the cross-examination of the German general Hermann Göring. Now, for those of you who don't know, Hermann Göring was an exceedingly evil man. He was responsible for the deaths of many hundreds of thousands of Jews, trade union activists, and homosexuals during the war. He was an evil man, ladies and gentlemen, but he was also a brilliant man. He had an incredibly high IQ, albeit he began to use heroin and cocaine towards the end of the war. But here he is at Nuremberg fighting for his life. And each case, including Göring's case, had 4 prosecutors, an American, an Englishman, a Frenchman, and a Russian. And John Wheeler Bennett describes the cross-examination that took place of Hermann Göring during that trial. Firstly, the American, Robert Jackson, the chief prosecutor for the US, whom Wheeler Bennett describes as at times brilliant, but at times Göring got the better of him in court during cross-examination. Why? According to Wheeler Bennett, because he was not properly prepared. A little hint back to my 3 rules of advocacy from earlier. When Jackson got into trouble, it was the English King's Counsel, who wasn't as powerful as an advocate as the American, but would sidle in and get Jackson out of trouble. Then the French prosecutor, described by Wheeler Bennett as wearing the most wonderful grey woolen 3-piece suit, silvery hair, lovely high top-button collar, pocket handkerchief, very good looking, very charming, and totally useless as a cross-examiner. That was the Frenchman. And now the point of the story, the Russian. Wheeler Bennett describes the Russian cross-examiner as 25 stones in human form of heavy-going Russian tank, And once the wheels of this tank got in motion, nothing stood in the Russians' way. And he describes the Russians' cross-examination in the following way. Let's not just describe it. Let's recreate it. Now, Dr. O'Neill, you've seen this before, so you know what to do. You've not seen this one before. Dr. O'Neill is going to play Hermann Goering. He's probably the most Hermann Goering-like individual in the room tonight. But Dr. O'Neill is going to play Hermann Goering. Rory, what I'm going to do is we're going to recreate this. I'm going to imagine we're in court, and I'm going to hand you a document, right? I'll do it in a moment. And I'll ask you to read it. We'll then speed the process up, and I will say, have you read it? To which your answer is yes, or if you want to be in character, ja. And I will then put a further question to you, to which your answer is no, or if you want to be in character, nein. So, hand you a document, take it, read it. Have you read it? Ja. Next question, nein. Also clear? I also try to do Russian voice to make cross-examination as realistic as possible for demonstration purposes. So here it is, from the top, the Russians' cross-examination of Hermann Goering. Hermann Goering! I hand you a document. Take it. Read it. Have you read it? Do you now confess yourself to be a fascist beast? Hermann Goering, I hand you another document. Take it. Read it. Have you read it? Do you now confess yourself to be a fascist beast? Hermann Goering, I hand you another document. Take it. Read it. Have you read it? Do you now confess yourself to be a fascist beast? This went on for a day and a half. That is all the Russian did in his cross-examination of Goering was hand him a document, get him to read it, and would then explode, obviously in Russian being translated for the court, do you now confess yourself to be a fascist beast? And very similar to Rory, Goering sits there and goes, nein. Well, ladies and gentlemen, that's examining crossly. And if you're ever in court and you feel the urge to reach out to your witness and strangle them, let that story resound in your head. A round of applause, please, for Dr. O'Neill. Without doubt. Without doubt, the best Hermann Goering we've had today. Commandment number 7, avoid repetition. I need to speed up a little bit. Avoid repetition. When a witness gives evidence in court, it may be done by way of witness statement, it may be done by way of oral evidence. It doesn't really matter which. But when you come to cross-examine, try, if at all possible, to try if you can, to avoid repeating large chunks of what the witness has already said in their statement or orally. It doesn't get you anywhere. It's meaningless. You said a moment ago X, Y, Z. Yes. You said a moment ago X, Y, Z. Yes. You said a moment ago X, Y. It doesn't achieve anything. Remember, folks, what I said at the outset, that cross-examination was all about challenge. And you may wish to repeat a small bit of the evidence before putting in the challenge. You said in paragraph 4 of your evidence that you arrived at 9 a.m. Yes, that's repeating, but I'm instantly going to follow it with a challenge. It was actually 11 o'clock, was it not? No, it was 9 o'clock. Repeat small bits. Don't, for the sake of it, simply repeat large chunks of the evidence that you've got. And in fact, I know, for those of you who are here at the university, I've actually taught, if not certainly seen, but may have taught the case study that you guys are using, I think, for the cross that you're going to be doing. Yes? Steve told me that. Yeah. So again, you've got witness statements in there, guys. When you're actually doing your cross-examinations, try to avoid just repeating large chunks of the statement. Work out what you need to challenge it, sit down. It's back to being brief. A little confession. I said at the outset that these were the 10 commandments of cross-examination. There aren't really 10. There are really only 7 or 8. But I spell them out to make 10 because that has a greater biblical and literary ring that appeals to me. So, of course, number 8, never ask a witness to explain anything. This, of course, goes hand in hand with commandment number 4. If you are only asking category 2 questions, you will never in cross-examination say to a witness, how come? How can that be? Explain. And we've already had an example of it. Remember when we used Anna as the witness? I said, your name is Anna, you're 50, you live in Warsaw, you've lived here all your life, you got here tonight by foot. And then I ask the why question. Why didn't you come on the bus? It's the same thing when you ask for an explanation. The other thing that I've learned through my own experience is that if you ask a witness to explain something, you lead them down that garden path, you get them in the corner, and you'll tend to find that the urge to ask for the explanation begins at the knees, and before you know it, oh, explain, how can that be? If you actually do that, folks, the witness will do exactly what you told them to do. They will explain it, and they will dig themselves out of whatever hole trap you are laying for them. So the word explain will never leave your mouths. Commandment number 9 is an old one, but again, it goes back to what I said about preparation. If a witness says something surprising during cross-examination and you think, ooh, that's interesting, don't go exploring, because you don't know the answer to the question you're going to ask. You don't know what the witnesses are going to say. No matter how curious you may be to know the answer to a question, if you don't know what the witness is going to say, or you don't know what the likely answer to the question is going to be, don't ask it. That's back to preparation. When you've prepared your cross-examination, you must know the answer or the likely answer to every question you ask. And finally, commandment number 10. And you're not going to break this one without a bit of experience behind you. But I leave it in because the story that goes with it is still one of the best moments of my career. And we're going to go back about 17 years, maybe slightly less, maybe 15, 16 years. And in order to get this, you've all got to have an imagination. And for those of you who wish to close your eyes and try and picture this in your minds, and I'm going to be listening out, or if you think you work out where I'm going with it, stick your hand up, and we'll see how many people get it. I'll do it in stages. Many years ago, I was prosecuting a criminal case, charge in the UK, grievous bodily harm, GBH, we call it over there. Circumstances of the offense, very simple, that the defendant, the criminal, and the victim were in a central London park, and they got into a fight in the central London park, and in the course of the fight, the defendant gets his teeth around the victim's nose, bites it off. Now, for those of you who've studied personal injury work, you'll know that this is perfectly possible. The jaw is the strongest voluntary muscle in the human body. Your teeth are like chisels. The nose is mostly made of cartilage. There's very little bone. So you can actually, you'll find, bite someone's nose off very easily. Try it on your loved ones when you get home tonight. Just go up to them and say, darling, can I try something? Yeah, and sort of go and bite their nose off. And you'll find you can bite it off very easily. So we get to trial. And here's where you've got to start imagining, because there was a delay to starting the case, because the judge couldn't stop laughing, and I couldn't stop laughing. She's worked it out already. The judge couldn't stop laughing. I couldn't. My opponent couldn't stop, and the jury couldn't stop laughing, because the victim turns up at court with hardly any nose. The surgeons haven't been able to sort of put the nose back on. So he's only got sort of 2 little holes in his face. Now, I think the lady up there has worked it out already on clue number 1. Okay, here comes clue number 2. Clue number 2 is he was bald. He had no hair. Yes, right. Now, where am I going? Where am I going? Spot on. Because not only was he bald and had no nose, but he was also, this case was in February. And it was cold in the UK, and he was wearing a long black raincoat. So you had this long black coat, the bald head and the nose. And you know, even during his evidence, he held a pen in his right hand, and we were all waiting for him to look at the jury and go, Avada Kedavra! Yes, indeed, you've worked it out. We had Lord Voldemort in the witness box, and it was brilliant. But the point of the story is this. In that case, my opponent cross-examined one of my eyewitnesses. And I guess he breaks about 6 commandments in one question. But I'll do both parts of the cross-examination to illustrate the point. The commandment is avoid the one question too many. Appreciate when the job is done, when you've got the ammunition that you need, don't go any further. Stop and sit down. I had an eyewitness who gave evidence. He saw it happen. Fine, here comes the cross-examination. Mr. Maxwell, you were in the park that day for a particular reason, weren't you?
Yes.
You were there to pursue your favorite hobby.
Yes.
Your favorite hobby is bird watching.
Yes.
You like looking at birds. Yes. And it's right, isn't it, that birds live in trees, don't they?
Yes.
Can we have a look at a plan of the park? And we had this scale drawing of the park.
Yes.
You see, Mr. Maxwell, that all the trees in the park are around the edge of the park.
Yes.
There are no trees in the center of the park.
No.
And the incident that we're concerned with took place in the center of the park.
Yes.
Where there are no trees.
Correct.
So you were looking at the birds in the trees.
Yes.
And the trees are around the edge of the park.
Yes.
And there are no trees in the center of the park.
No.
What should he have done there? Stopped. And what's he going to say to the jury in his closing argument? This particular witness couldn't have seen it. Had his back to him. He's looking at birds in trees. He couldn't possibly have seen what gone on. But did he stop? The one question too many. So, Mr. Maxwell, if you're looking at the birds in the trees and all the trees around the edge of the park, and the incident we're concerned with took place in the center of the park, how can you possibly tell this jury that you saw the defendant bite off the victim's nose? And the answer came like a bullet out of a gun. And he just stood there and said, well, it was perfectly simple. I was looking at the birds in the trees. I heard a scream. I turned round and I saw him spit it out. Cross-examination destroyed. So, those are the 10 commandments of cross-examination. A little bit of a health warning. As I said at the start, it's never going to be perfect every time. Whether you're doing it here as a student at the university using the wonderful exercise that you're going to put them through their paces on, or whether you're an advocate in real life, it's not brilliant all the time. I did one a couple of weeks ago, which I thought was dreadful. Even by my standards, I thought it was dreadful. So you're not going to nail it every single time you cross-examine a witness. You might get it, I don't know, maybe 4 times out of 5, maybe only 3 times out of 5. But if the witness doesn't play ball or things don't work, move on, change topic, move on to something else, try a different angle. And of course, if you're doing it for real in practice, remain calm on the outside. Before I take any questions, I'll just end with one other observation that may be of use. And I don't know whether we have access to such materials here at the university, but you can obviously advise in due course. I'm often asked all around the world, I don't know whether I've got the talent, and I can learn procedure, I can learn evidence, but 50 cross-examinations, that's a lot of cross-examining, to get the experience. Is there a way of shortcutting it? Can I shortcut the 50 cross-examinations? And the answer is yes, and the answer is no. I don't personally believe there is any substitute from seeing 50 witnesses in action, how they react, how they behave, how they answer your questions. But by the same token, what you can do is read. And I don't mean read law. Hell, we don't want to read law. Law's boring. What I do is read about classic trials and classic advocates from history. There's a small library of such books. The one that's readily available on Amazon, written by a dear friend of mine, Ian Morley, Queen's Counsel, is called The Devil's Advocate. A new edition of, lady nodding there, a new edition of The Devil's Advocate came out last year. And what makes that book so good is within it, Ian sets out bits of transcript of successful cross-examinations where a great lawyer like a Marshall Hall or an Edward Carson, deals with a particular witness and solves a problem. And if you read that, you almost experience the cross-examination as though you were there with that great advocate. And if you find in that little bit of transcript, and there are other books with transcripts in them, find them. I mean, we may have some here, I don't know. But if you can find that a great advocate solved a particular problem or achieved a particular objective, nick it. There's no copyright on the content of the cross-examination. Use the same questions. Because if it worked for that great advocate in the past, the chances are it will work for you in 2021. I'm bang on time. Any questions? Don't be afraid, I don't bite. I'll just go for a wander. I'll come up and see my friends up here who I feel as though I have neglected. Hello. Nice suit. James Phillips, London. I have two myself. That was from Die Hard, of course. Good evening. Any reason why you're at the back? Are you scared or are you... No, all right, fine.
Anybody have any questions for Alastair?
Yes, there is. In practical terms, there is. You are being far more direct with a witness if you are putting a Category 2 question, because you are suggesting the answer. The putting of a Category 3 question, your name is Anna, is it not? Boom, it's in the face, and it's pretty much going to be a yes answer. Is your name Anna? That almost invites the witness to give a little comment. Correct. Absolutely. So I would stick in the main to Category 2. You will control your witness far more with the Category 2 question. You can have the odd Category 3, and indeed, in the UK now, we now have separate advocacy training for advocates to deal with vulnerable witnesses, those with mental incapacity or whatever it might be. And the training on those is to actually do the majority of the questions being Category 3 rather than Category 2, because the witness is fragile, the witness is vulnerable, and the thinking is that too many Category 2 questions, the witness won't be able to deal with that. So it's very much a softly approach in cross-examination. Yeah, stick to your guns. Sorry, English phraseology. I suppose. It's keep going. I mean there will be cross-examinations you do where a witness will get the better of you. And you might think to yourself, oh, why don't I just give up? Don't ever do that. Find a different topic. Find something else in your notes that you've prepared and just change topics. Tell the witness, I'm now going to move on to the events of the 17th of May and see if you can make better inroads through that alternative topic if the witness is running rings round you on the first topic. That's what I mean by sticking. Effectively, the Peter Gabriel song, Don't Give Up.
If I may came back to the commandment number 6, when there is where we cannot be annoyed by whatever the witness says, and I would like to ask if there is any sort of technique that we can use to annoy the witness so much that he may start shouting or doing unreasonable things and completely destroy his own credibility.
Yeah, actually, the best way in terms of advocacy is to adopt a very, very softly approach. If you know in a particular case from your own witnesses that a witness on the other side is likely to explode or has an attitude problem, the best way to actually get under their skin is back to the Hannibal Lecter routine. It's very, very soft because they'll hate it. They won't like it. I've just finished. I wasn't doing the case, but there's been a case on the island of Jersey where I was brought in as a cross-examination consultant to advise on the content of the cross. And the first question I asked the advocate is, what's this guy like? And the advocate said, he's explosive. I said, right, well, in which case we need to change style here. We need to go in very, very softly. And what that meant was that in 3 days of cross-examination, he exploded no less than 37 times. Job done, as far as that's concerned. So if you've got someone who is prone to exploding, go as soft as you can, without doubt. That's the best thing to do. Yeah. Well, what the historian? John Wheeler Bennett. John Wheeler Bennett, yeah. No, he was the historian who... He's not a lawyer, he's just I don't know the name of the Russian cross-examiner. No, he was an academic. I think he was at Cambridge University, and he was a history person. And all his role was, he wasn't involved in any of the trials. He sat at the back of the court, and he simply wrote down what he heard. Yeah, purely a historian.
The mic. Or Alastair can give you his.
What can... Doesn't work. Oh. What can we do with civil procedure document, for example? Because, okay, explode. State document.
That's getting into, there's a method, and you'll find it if you look up Ian Morley's book. I think it's described in there. But there is actually a method that we teach on how to cross-examine a witness where there is an inconsistency in what they've said in court with what is in a particular document. I haven't got the time to go into it now. You can probably find it online. The method is called CAPRI, C-A-P-R-I. And if you're very good, Dr. O'Neill may even have some vintage video footage of me in Poznan talking about CAPRI. But it's a method by which you cross-examine the witness to show where what they've said in court is different to what's in documentation. But as I say, I would need a good half hour to an hour to do justice to it. But there is a means, and it does exist. Yeah. There was somebody. Yeah. Yes. You want my honest answer? Because I think 40 is too few, and by 60, you've probably got the experience. No, it's just, I guess I look back on my own cross-examination career, well, own career as an advocate, but in particular, looking at cross-examination, and actually say to myself, when in my career did I get it right almost totally for the first time? And I would have said it was around about my 50th cross-examination. That's the only magic there is to the number 50. Of course, if you find you have the talent after only 3 cross-examinations, then you're away and you're brilliant. But I think the 50, it's just that level of knowing what witnesses do, seeing different witnesses' reactions. You build up the memory bank, and that arms you for the next case. There's no magic to it that way.
To answer the question on Ian Morley's book, The Devil's Advocate, we do have at least 1 copy in the office, so if anybody does want to borrow it, that is possible, so just send us an email. You can also buy it. There's a Polish version of it, but I recommend that you buy the English version. Any final questions?
We've talked about some optimistic scenarios, how to get from the witness good information, good evidence for us. Yeah. What if the witness handling doesn't work well? Even our preparation, good questions, witness don't want or doesn't cooperate well.
Yeah.
And we have, for example, 20, 30 questions, but each questions provide us not exactly this what we want, when we should stop or we should continue our scenario until the end.
Yeah. Two points arising out of that. One of the advanced techniques that I would very often teach, firstly to keep a witness on side, is that when you've written your cross-examination, when we're doing our checklists, an additional one is to be certain that the witness will answer yes to the first 10 questions, because they then feel as though this isn't as bad as we thought it was going to be, and that keeps them on side. The second aspect of your question, which I think is a good one, and is again something I would do in a more advanced training, it goes back to commandment number 4, that if you're only asking category 2 questions, in theory, there are only 2 possible answers, yes, no. Do witnesses in real life always answer yes or no? Of course they do. Yes, but blah, 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 blah. No, but blah, 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 blah. How do you deal with that scenario? Well, it came to me only 2 years ago. A very dear friend of mine, Darren Almeida, who's a young barrister in London, who plays golf. I play golf. We've played golf together. Darren and I had a drink one night, and he was doing a trial where he had a witness in the trial who did exactly that. It was all yes, but, blah, 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 no, but, blah, blah. And he said to me while we were having a drink, he said, how do I deal with that in my closing to the jury? And I said, I haven't got a clue. He said, but you're a professor of advocacy, you should know. I said, no, I simply don't know. Well, folks, 7 whiskeys later and a bit of sleep, at 2 a.m., Darren was overjoyed when I rang him at 2 o'clock in the morning, because a eureka moment had come to me. And it is the closing to the judge or to the jury. But you have to, in order for this to work, and it worked for Darren because he did it the next day, you have to be compliant totally with commandments 1, 2, 3, and 4. And your preparation must be meticulous. And when you get to the closing, this is what you say to your judge or your jury. Your Honor, you will recall 2 days ago when I cross-examined Dr. O'Neill, and hopefully your Honour's record matches mine, that I asked Dr. O'Neill 30 questions, all of which were short, all of which contained only one piece of information, and all of which were leading, which one might have thought would have elicited a yes or no answer from Dr. O'Neill. Looking at my note, Your Honour, and I hope Your Honour's note reflects this, Dr. O'Neill only answered yes or no to 3 of my questions. In respect of 27 of them, he felt the need to elaborate on the answer. And Your Honour, if Dr. O'Neill is unable to give a simple answer to a simple question, his credibility should be in doubt. And that's exactly what Darren did the next day in his trial, and the jury found in his favor. And I've deployed it myself since. It's a great way of dealing with the witness that waffles. And that's what I would try. Try it out, see if it works. I mean, in fact, the reality is if he were ever a top man.
And can we give another big round of applause to Alastair as well for giving us...
Pleasure.
Thank you very, very much. I can think of no better way to start a miserable weekend with a high-energy performance from Alastair Hodge himself. Thank you.
Pleasure, as always.
Have a great weekend, everybody. Thank you for coming tonight.